Did you know the ATO recently lost a tax residency case? And what's interesting isn't that they lost, it's why they lost. Because this taxpayer had several facts that would normally cause serious concern from an Australian tax residency perspective. He had a home in Australia, his wife remained in Australia, his child remained in Australia, he continued spending time in Australia, and yet the tribunal still found in his favour. So what happened? And more importantly, what can Australian business owners, investors and professionals learn from this case if they're considering relocating overseas? Because while this taxpayer ultimately won, I don't think this case should make anyone comfortable. In fact, I think it highlights exactly why residency planning needs to be done properly before you leave Australia. The case involved an individual who was living and working in Singapore. The ATO argued that despite his move overseas, he should still be treated as an Australian tax resident. The taxpayer disagreed. The matter ultimately ended up before the Administrative Review Tribunal. And that's where things became very interesting, because this wasn't simply a question of whether he lived in Australia or Singapore. The tribunal had to apply the Australia-Singapore tax treaty tiebreaker provisions. These are the rules used when two countries may potentially claim the same person as a tax resident. And when that happens, the treaty contains a series of tests to determine which country has a stronger claim. The first question was straightforward. Where did he have a permanent home available to him? The problem was that he effectively had one in both countries. He had accommodation available in Singapore, but he also had a home available in Australia where his wife and child continued to live. As a result, the tribunal could not resolve the issue at that level, so they moved to the next test. The next question was, where was his habitual abode? In other words, where did he ordinarily live? Where did he return to? Where was his regular place of life? Again, the facts were not entirely clear. There were arguments supporting both Australia and Singapore. So once again, the tribunal couldn't definitively resolve the issue at that stage, which meant they had to move to the next and often most important level. This is where the case became particularly interesting. The tribunal looked at his personal ties and they looked at his economic ties. Personal ties includes things such as your spouse, your children, your close family relationships, your social connections, your community ties. Economic ties includes things such as where you earn your income, where your business activities occur, where your investments are managed, where your day-to-day economic life is centered. What ultimately helped this taxpayer was not the existence of a tax treaty. It was the fact that his life was genuinely centered in Singapore. He wasn't simply traveling through Singapore. He wasn't working remotely from a hotel room. He wasn't trying to argue technicalities. He was actually living there, working there, earning there, and conducting the economic activities that supported both himself and his family there. That distinction matters because tribunals tend to look beyond labels and focus on what is actually happening in real life. And in this case, the evidence showed that Singapore had become the center of his economic life. The tribunal accepted that many of his personal ties remain connected to Australia. This is exactly why residency cases cannot be reduced to a simple checklist. Having a spouse in Australia is often a very significant factor, but it doesn't automatically make you a resident. Having a home in Australia doesn't automatically make you a resident. Spending time in Australia does not automatically make you a resident. The outcome depends on the overall facts and circumstances when viewed as a whole. After all, his wife and child were still there. That is not a fact you would normally want in a residency case. However, the tribunal also found that his economic life was overwhelmingly centered in Singapore. He was working in Singapore, he was earning his income in Singapore, his day-to-day activities occurred in Singapore, his economic center of life was in Singapore, and importantly, the tribunal placed significant weight on those economic ties. Ultimately, when all the facts were weighed together, the tribunal found that Singapore had the stronger overall connection. As a result, he was treated as a Singapore tax resident under the treaty tiebreaker provisions, and the ATO lost. Now, this is where many people read a case like this and draw the wrong conclusion. They think, fantastic, I can leave my family in Australia, I can keep my house, I can keep coming back, and I'll be fine. That is absolutely not the lesson from this case, because every residency case turns on its own facts, and small differences can completely change the outcome. A different pattern of travel, different family circumstances, different economic activity, different assets, different income sources. Any one of those factors can produce a completely different result, which is why relying on somebody else's tribunal win is a very dangerous strategy. The real lesson is not that the taxpayer won. The real lesson is that he had to go to a tribunal to get there. Think about that for a moment. Years of uncertainty, objections, legal submissions, professional fees, stress, time, and a dispute with the Australian Taxation Office. Yes, he won, but what did it cost him to win? Because in my view, if your residency position is only determined after years of litigation and a tribunal hearing, you've already paid a significant price. At WellSafe, we take a very different approach. Our objective is not to win residency cases. Our objective is to avoid them altogether. We want the facts to be so clear, the evidence to be so strong, and the planning to be so well documented that your position is obvious long before any dispute ever arises. That means getting the timing right, getting the sequencing right, understanding how residency rules applies to your specific circumstances, understanding family considerations, understanding business considerations, understanding asset ownership, and ensuring that the evidence supports the position you're taking, because residency is not something you want to leave to chance, especially when significant wealth, businesses, investments, and future income streams are involved. This case is a fascinating reminder that tax residency is rarely determined by a single fact. It's determined by the totality of the circumstances. And while the taxpayer ultimately succeeded, I don't think anyone would volunteer to spend years arguing with the tax office to get there. The goal isn't to win residency disputes. The goal is to structure your affairs properly so that you never end up in one. If you're considering relocating overseas, already living overseas, or you're uncertain about your current residency position, now is the time to review it, because the cost of getting residency wrong can be substantial. And as this case demonstrates, the consequences often don't become apparent until years later. Thank you for watching, and I'll see you in the next update.